Section 14, Legal Hotline Q&A, Arizona Fair Housing 101. The questions keep coming. After their discussion about fair housing investigations, Sarah looked at David and laughed. "I've come to one conclusion," David smiled. "What's that?" "The more I learn about fair housing, the more questions I seem to have." David laughed. "That's called practicing real estate. Fair housing isn't something you master in one afternoon. It's something you continue learning throughout your entire career." He opened another legal hotline file. "Let's work through a few more situations." Legal hotline question number 1. Does the Equal Housing Opportunity logo have to be a certain size? Question. A licensee is preparing an advertisement for a local publication. How large does the Equal Housing Opportunity logo have to be? Answer. There is no single required size for every advertisement. David explained that HUD has long encouraged the use of the Equal Housing Opportunity logo, slogan, or statement to educate the public that housing is available without unlawful discrimination. Traditionally, the size of the logo depended on the size and format of the advertisement. Today, however, advertising appears in many formats, including websites, social media, mobile devices, digital flyers, email campaigns, and printed publications. The important point, David explained, is that your advertising should clearly communicate your commitment to fair housing. Whenever practical, Arizona licensees should include the Equal Housing Opportunity logo or statement in advertising and follow current brokerage policies and applicable advertising requirements. Broker tip: the logo itself does not make an advertisement fair housing compliant. The words, images, videos, and overall message must also comply with fair housing laws. Legal hotline question number 2. Assistance animals and no pet rules. Question. A homeowner association prohibits pets. A resident with a disability requests permission to keep an assistance animal. Can the HOA enforce its no pets rule? Answer. In many situations, no. David explained that assistance animals are not considered pets under fair housing laws. If the animal provides assistance or emotional support related to a person's disability and qualifies as a reasonable accommodation, the housing provider generally must modify its pet policy unless doing so would create an undue financial or administrative burden or fundamentally alter the nature of the housing program. Fair housing requires us to look beyond the label of pet, David explained. The real question is whether the animal is part of the reasonable accommodation. Legal hotline question number 3. Can a landlord charge a pet deposit for an assistance animal? Question. A landlord requires every tenant with a pet to pay a pet deposit. May the landlord charge the same deposit for a tenant's assistance animal? Answer. No, because an assistance animal is not treated as a pet under fair housing guidance. Housing providers generally may not charge pet deposits, pet rent, pet fees, or similar charges solely because a tenant has an approved assistance animal. David reminded Sarah that tenants remain responsible for any actual damage caused by the animal, just as any tenant would be responsible for damage they cause to the property. The accommodation doesn't excuse property damage, David explained. It simply prevents additional charges because of the disability. Broker tip: never assume that every animal qualifies as an assistance animal. Housing providers may request reliable information when a disability or disability-related need is not readily apparent, consistent with current HUD guidance. Legal hotline question number 4. Should a listing agent disclose a nearby recovery home? While preparing to market a property, a listing agent learns that the neighboring home is occupied by individuals recovering from alcohol addiction. Should the listing agent disclose this information to prospective buyers? Answer: generally, no. David explained that individuals recovering from alcoholism may be protected under fair housing laws if they meet the legal definition of a disability. Licensees should avoid disclosing information about neighbors that identifies or suggests membership in a protected class, just as they would avoid discussing the race, religion, disability, or other protected characteristics of neighborhood residents. Our job is to market the property, David explained, not the personal characteristics of the neighbors. Legal hotline question number 5. Accessibility in commercial buildings. Question. A commercial office building was constructed decades ago. A tenant employs an individual who uses a wheelchair, but the office restroom doorway is too narrow to provide access. Who is responsible for complying with accessibility requirements? Answer: potentially both the landlord and the tenant. David explained that this situation falls primarily under the Americans with Disabilities Act, or ADA, rather than the Fair Housing Act, because it involves a place of public accommodation. Depending upon the circumstances, both the property owner and tenant may have responsibilities for complying with applicable accessibility requirements, even if they allocate those responsibilities differently in the lease agreement. The Fair Housing Act and the ADA often work together, David explained, but they don't cover exactly the same types of properties. Knowing which law applies is just as important as knowing the law itself. Sarah closed her notebook. I've noticed another pattern. David smiled. Almost every fair housing answer begins with understanding the facts before applying the law. David nodded. And that's exactly what good brokers do. They don't jump to conclusions. They gather the facts. They understand which laws apply, and then they help their clients make informed decisions. Arizona broker tip. Many fair housing and ADA questions overlap, but they are not identical laws. Before advising clients on accessibility, assistance animals, or commercial property issues, determine which law applies and consult your designated broker or qualified legal counsel whenever the answer is uncertain. Online discussion. Question 1. Why is it important to distinguish between an assistance animal and a household pet? Answer. Assistance animals may qualify as reasonable accommodations under fair housing laws and generally are not subject to standard pet restrictions or pet fees. Treating them as ordinary pets may create a fair housing violation. Why should a real estate licensee avoid discussing the personal characteristics of neighbors with prospective buyers? Answer. Discussing the race, religion, disability, or other protected characteristics of neighborhood residents may violate fair housing laws and improperly influence a buyer's housing decisions. Licensees should focus on the property and objective facts. Question 3. Why is it important to determine whether the Fair Housing Act or the Americans with Disabilities Act applies to a particular situation? Answer. The two laws cover different types of housing and public accommodations. Understanding which law governs the situation helps ensure that the correct legal standards are applied.